ladies and gentlemen, we're going to get started in about 5 minutes. We will start promptly at 1 o'clock. We will have a couple of handouts out front that Mr. Rovner is going to be going over. He's going to start at 1 and he has to leave. We have a hard stop for him at 1:10. So Naisha Waller is going to make those handouts available for you. Thank you. Thank you, ladies and gentlemen. There are a couple of caucus meetings, so we're going to be having folks kind of committee members kind of trickle in as time progresses. But we understand our first speaker, Mr. Rovner, actually does have a plane to catch, so quite literally. So we're going to go ahead and hear from him. Mr. Rovner, if you want to, at the table or the podium? Okay.
Thank you again, Madam Chairman. I appreciate being invited back to speak. I spoke to this committee a couple weeks ago. My name is Josh Rovner. I am the Senior Advocacy Associate at the Sentencing Project, a think tank in Washington, D.C. I work on an array of juvenile justice issues, including the successful implementation of bills such as this one. When I spoke on January 28th, I emphasized a couple of main points to the committee, but I think the one takeaway that I hope the committee understands is that the declines in youth offending have provided breathing room for implementation of a bill like this one. And there's a couple things that have changed in just those 2 weeks that I think are important to bring to the committee's attention. One of them is that when I presented, the most recent arrest data was through 2017, and GBI, while they haven't posted it publicly, was kind enough to provide me with 2018 data on juvenile arrests. And the other is that the state auditor has provided a fiscal note on HB 440. That's what I'll talk about. It won't take very long, and then I'll be happy to take any questions. First, let me talk about the arrest data, and I've entered something into the committee's record that looks a lot like this. This shows the arrests for all youth under the age of 18. Previously, what I had was available through 2017. Now I have available through 2018. Again, this isn't my data. This is from the Georgia Bureau of Investigation. And what's really been remarkable, I think this is wonderful news that the committee and the whole state of Georgia ought to celebrate, is the continued decline in juvenile offending and juvenile arrests in the state. And so now we have, over the 10 most recent years, again, a 60% decline in arrests for youth under the age of 18. That has meant that when you look at the total number of youth referred to juvenile plus criminal court in 2018, that number is still smaller than the total number just referred to juvenile court alone in 2015. That is a wonderful piece of news that ought to be informing the committee's deliberations. Second is the new fiscal note. That fiscal note follows up on a fiscal note that was issued in 2017. In 2017, the state auditor estimated that there'd be annual construction costs of $110 to $150 million, one-time construction costs to build new facilities. Again, I said that offending has declined, and yet the estimate for new facilities has gone up from as low as $110 million to $199.7 million. Again, offending has declined. The auditor's estimate has increased. Recurring costs has gone up from 2017. The original recurring cost estimate was $47.6 million. The auditor now says it will be $64.6 million. Again, offending has declined, but the estimate has gone up. I concluded my remarks last time asking for the ability to amend my remarks when a new fiscal note was issued. That new fiscal note has been issued, so I'm very glad to be here. And I have a couple fact sheets to enter into the record. One of them is titled, Adding 17-Year-Olds Won't Cost DJJ $50,482,632 a year. It's very hard to believe in an era of declining offenses and half-empty facilities, given the high costs of running a facility year to year, that there would be additional costs like that. And the other is about the purported need for 4 new RYDCs and YDCs. I contacted it was handed to me secondhand from DJJ, and I had a one-day count of February 12th, 2020, as we meet here today. So on that day, there were 862 youths in the secure detention facilities. Again, 862 youths held there that day. Georgia has 19 YRDCs. They have capacity for 1,204 youths. Some quick math shows that they are 71% full, or if you're an optimist, 29% empty. In the YDCs, Georgia has 7 of them. The one-day count, again, February 12th, there were 366 youths held in the YDCs. YDCs have functional capacity for 746 youths and authorized capacity for 847 youths. That's 50% full or 50% empty. So again, I have a lot of trouble with the state auditor's estimate, assuming that there'd be a need for 4 new facilities when the ones that exist are not full. And I have a hard time understanding the need for additional recurring funds in a time of declining youth offending.
Thank you so much. Committee members, do we have any questions?
This is
Representative Oliver.
my confusion. When did we get the new auditor report on the new figures?
That was received by the chair just immediately prior to the meeting.
I knew
The last
I knew
meeting.
there was a reason I hadn't known it, but so you're handing it out. I mean,
Yes.
we'll get it.
Mm-hmm.
That's what you. I
Yes.
hadn't seen the new one, the new auditor. So thank you.
I
Yes,
think
it
was
contemplates 4 new facilities. I'm sorry.
yeah, that's fine.
Anything else? Okay. Did you want to just touch on the annual costs as far as the second handout that you provided to the committee?
Yeah, so the main annual costs that the state auditor found was a need out of $50.5 million. 44 million of that was for operating costs for the RYDCs and the YDCs and for community services. Even with the proposed cut from the governor's budget, we've still seen sharp increases in the annual budgets for those agencies, for those divisions within DJJ. Going from FY 2011 to FY 2020, which is not the governor's proposed cut, but the actual enacted budgets. In those years, the total DJJ budget increased by 20%. These are years that the total referrals declined by 60%. There was a 40% increase in budget for the YDCs, a 23% increase for the RYDCs, and a 16% increase for community services. So certainly the agency has seen its budget increase over these years. And while I would expect that there will be some impact on the agency budget, it's not at all clear from the auditor's estimate where the $50,482,632 comes from.
Okay, thank you. Representative Oliver.
The only reason that they could get a $50 million figure, I'm speculating, and it's a report I haven't really drilled down into yet, is that they're assuming a certain number of days incarceration based on the arrest records. Is that what they're doing? Or can you tell?
I wouldn't want to speculate either, but it seems to me that facilities like a YDC have high annual fixed costs and low flexible daily costs. The heat and the light and the staff, they don't go home if there's 40 kids there instead of 45. The main costs in running a facility are going to be the same regardless of how many kids are there. And when the facilities in many cases are half empty, and in total 71% empty for the detention centers, it's very hard to see where there'd be much additional cost, certainly not on the order that's being discussed here.
One of the reasons that the budget might have gone up, and there are budget people that would understand this better, is the diversion of money to treat people in the the juvenile court, the use of money for treatment services. In your study of implementation of Raise the Age, what is an evaluation of the use of those monies being spent in the community as versus to secure beds, or do you have any thoughts on that?
Well, we do know that incarceration is really the most expensive treatment that we could possibly give a child. And we also know that in general, that it's the least effective, that putting kids in these facilities changes their peer group, it changes who they are influenced by, and it doesn't necessarily give them the tools to reform for when they are home. If they're able to succeed in the facility, is not the same thing as being able to succeed when they come home. So to your question of the best place to spend the money, the community-based alternatives are going to be much more successful than the facilities themselves. I mean, it's really why I'm happy to see that the governor is ready to close the Sumter the Sumter YDC. That's $11 million that could be spent elsewhere in the system.
Thank you.
Thank you, Representative Oliver. And it's 1:10, and we appreciate your staying around. And so we will go ahead and let Mr. Rovner get on his way. Thank you again for providing some clarity to that. Committee members, I will be forwarding the fiscal note. I had thought that had already been disseminated, but I do apologize for that. Next on the agenda is the Georgia Association of Criminal Defense Lawyers. Oh. Another table. No, it's all good.
Okay, thanks. Go ahead.
Usually the PowerPoint kind of goes with the podium, so.
Yes, well, we have, so thank you for having us today. My name is Maisie Lynn Causey. I am the policy advocate for the Georgia Association of Criminal Defense Lawyers. I'm joined by our Juvenile Justice chairperson, Randy Waldman.
Okay, sorry, I'm going to have to be a cow. You have to speak clearly into the mic and kind
Okay.
of speak up a little bit because
Sure,
I'll
sure,
start
sure.
getting the text from
People that are
members
trying to listen, yes,
watching
of
and they
course.
can't hear,
Okay.
so.
Sure. My name is Maisie Lynn Causey. I am the policy advocate for the Georgia Association of Criminal Defense Lawyers. I'm joined by Randy Waldman. She is GACTL's Juvenile Justice chairperson. We're also joined today by members of our organization who practice in state, superior, and juvenile courts. And they will be taking the podium in turn. Jason Costa will be bringing you some information about the state court perspective on HB 440. Ben Githiea will bring you a superior court perspective on the bill. Jill Roth will bring you a juvenile court perspective, and along with Mike Randolph and Amy Bell, who also have a unique juvenile court perspective in that they are part of a school justice partnership in Bibb County and Peach County, I believe. I might be getting the second county wrong. So we'll just kick it off with Jason Costa with a state court perspective.
Good afternoon. Thanks for having me. My name is Jason Costa. I've been a lawyer at the DeKalb County Public Defender's Office for 13 and a half years. I supervise our entire misdemeanor division, so I've got a lot of firsthand experience that I hope will be helpful. I've watched some of the other hearings. I've been struck that a lot of the information seems to be, here's a very broad generalization about 17-year-olds within the criminal justice system without a lot of information backing it, or here's one situation that I had one time with one individual. So I'm going to try to do something very different than that. I'm going to try to give you a sense of what it's like on the ground, in real life, what these charges look like in terms of misdemeanors in Georgia. I have personally handled a little over 3,300 misdemeanors over the last decade. So I'm putting this on a very solid foundation of real-world experience, okay? And please, obviously, interrupt me if you have any questions at all. The first key thing I really want to emphasize is when we're talking about 17-year-olds charged with a crime, the vast majority, as you can see, are misdemeanor charges. It's almost 3 to 1. So I know it's easy to get lost in the weeds. These are the charges that most 17-year-olds that are facing criminal charges in Georgia are facing are misdemeanors. Again, almost 3 to 1. I want to walk you through the process step by step and talk a little bit about it. I thought the most helpful thing, first and foremost, was to give you a sense of what these charges really look like in practical terms. So this is the typical misdemeanors that are charged against a 17-year-old. So I'm going to walk through them fairly quickly because I think they're pretty straightforward. But when we're talking about charged with a misdemeanor, it seems kind of vague and fuzzy. This is in very practical terms what that means. Criminal trespass or damage, exactly what you think. Someone was somewhere they weren't supposed to be, they came back, or they wouldn't leave, or they damaged property that wasn't theirs. Disorderly conduct, I think everybody's got a good handle on. Fight with another student at school. Fight with a sibling, fight with a family member, fight with an acquaintance, somebody you know in the neighborhood. These are all the cases that we see regularly. A minor theft charge, not a minor, but a not significant amount of money theft charge, it's usually a shoplifting charge. Obstruction of a police officer, nonviolent by definition, running away, not cooperating in some way, and then giving false name or date of birth, possession of marijuana, and traffic offenses. This is it. This is the list. There are not a ton of hidden other charges. When we're talking about misdemeanors that 17-year-olds are charged with, this is the list. If I could have quantified it down to the number, I would have. I didn't have the ability to do that. But based on my experience, I consulted with all 7 attorneys that are currently handling misdemeanors in DeKalb. This is 90+% of the charges we see are on this list. So I think one big important note is when I was 17, I would hazard when many of you were 17, half of the things on here the police wouldn't have been involved with, right? A fight with siblings, a fight at school, traffic offense, yes, maybe, criminal trespass. These were things that have been more criminalized recently, and it's not just criminalized, it's criminalized on an adult level. So it has a huge impact, and I think that's important to realize. The next step in the process, obviously, and that I want to emphasize to all of you is the arrest, right? So these individuals are arrested, they're put in jail, they're in regular jail. There is not a special section for 17-year-olds in jail. There's not a younger people section in jail. They're just in regular old jail. And even though they are only charged with these types of cases, they are going to usually be in jail a minimum of 24 hours. If they're lucky enough to get a signature bond, they might be out in 24 to 36 hours. If their family is able to put together the money to bond them out, usually that'll happen within 2 to 4 days. If not, if their family can't afford to get them out, usually they're going to sit for somewhere between 6 and 12 days before they come to court. So let me say it again. If they can't afford to make bond, they're usually going to sit in the adult jail for 6 to 12 days on these charges before they come to court. If I were in custody for 6 to 12 days, that would have a huge impact on me. I'm sure the same for you. That said, I would probably not lose my job. I would probably not lose my place to live. That is not the case for most of these 17-year-olds. If they have a job and they're in custody for 10 days, they're going to lose their job. It's not like they've got a huge job history, It's not like they've got a huge job history where they're going to say, oh, okay, no, you've been with us for long. No, they've effectively lost their job. So that collateral consequence is enormous. A lot of their living situations are tenuous, and this amount of time away can have a significant negative impact on those living situations. So just the arrest itself can have a terrible impact. Now, I want to go on to what happens to most of these cases, how they get resolved. And I want to start with those folks that are in custody the longest, the ones I said are usually 6 to 12 days. When they come to court, their options are to plead guilty or to plead not guilty. Practically speaking, there's a chance that we could try to get a bond reduction, try to get them out of custody, but usually the choice is going to be get out and enter a guilty plea or stay in custody, which is not a choice for most of them. Usually they're going to enter a guilty plea at that point. The guilty plea is going to stay on their record. Obviously, when they apply for jobs, when they try to get into school, when they apply for apartments, it's going to have a significant impact on their ability to do that. Now, the folks that get out, right, the ones I said were kind of the luckier ones who get a signature bond or their family's able to afford posting bond, practically speaking, they're not going to come to court for 6 months, 9 months, 12 months. During that time, if they apply for a job or school or apartments, one of the questions that comes up all the time is, do you have any open criminal cases? Yes, they do. They can't do anything to move them along any faster. They can't do anything to resolve the case. It's just sitting there open. So that's a huge negative consequence that a lot of our 17-year-olds face. I do want to mention that we do have in DeKalb an excellent diversion program. And diversion is a very helpful thing. It's wonderful. Having said that, even a diversion program is typically going to take 9 to 18 months from the time of arrest until the case is resolved. And when you're 17 and you don't have a job or you're not back in school, 9 to 18 months is a long time to not be able to do anything because this is sitting pending, hung over your head. The other note I'll give is that not all jurisdictions have the kind of sort of a wide-ranging diversion programs that DeKalb do, or that DeKalb does. And so for a lot of young 17-year-old kids, this is not an option at all. Just to give one or two quick examples, we had, and this is not one time years ago, the last week, we had a 17-year-old who was arrested, brought to the jail. She had a medical condition. She had to go to Grady. They brought her back from Grady but didn't realize that she was back in the computer. So she sat at the jail for 3 weeks before she was able to come over. 3 weeks sitting at the jail. Very difficult. I had a case at the end of last year who was a student at school, was misbehaving, got in trouble. They said, go home. He said, no one's home. I'm not going home. So we went out to the parking lot. He stayed in the parking lot. They're like, no, you can't stay in the parking lot. So I don't have anywhere to go. So they called the police and they arrested him and charged him with criminal trespass. He's in that process now. If he gets out, great, but it's still going to be hanging over his head. So I can't emphasize enough how significant those collateral consequences are to these 17-year-olds. The last thing I'll say, and I want to make sure I can take any questions that you have, these are children. So I don't pull that out of thin air. I'm basing that on my experience. There is no actor in the criminal justice system, not the judges, not the prosecutors, not the probation officers, not the police officers, not the corrections officers, that talks to these 17-year-olds more than I and my colleagues do. And I see the fear they have, the lack of understanding they have, all of those things, and I can tell you firsthand, these are children. And I hope you'll be able to make the change to treat them as such. So I'm happy to answer any questions I can.
Thank you so much. Committee members, any questions? Representative Oliver.
Do you have any specific information on how long 17-year-old misdemeanors are held in DeKalb County Jail on average, or?
I don't have a calculated specific answer in terms of it. We don't have the ability to pull that specifically or particularly. I can tell you that in my experience, it's going to be somewhere between 2 and 12 days, typically. 2 and 12 days is about the amount of time before they're going to either come to court or get a signature bond, or their family's able to post bond for them.
I thought, in terms of segregation of minors, I thought there was some federal requirement of a segregation of minors in jails. Am I wrong about that?
I will tell you, I've toured the DeKalb jail probably 8 times. I've never heard or seen anything about any kind of, there's not a special, we call them pods, it's an area of the jail, there's not a special pod as far as I know for 17-year-olds. So no, I don't believe that's the case.
Madam
I could
Chair, would you
certainly be
mind
wrong.
if somebody else answered that question?
No.
Thank you, Committee. Randy Waldman. At the moment, JJDPA, the Juvenile Justice Delinquency Prevention Act, does not mandate if youth are tried as adults, does not mandate the sight and sound segregation that is otherwise mandated. That is going to change. Effective, I believe, 2021, there will need to be full and complete segregation of 17-year-olds, sight and sound segregation from their 18-year-old counterparts in the jail. I will note that's going to be expensive for all of our jails if we don't get to a point where we have raised the age in advance of that. One of the downsides of sight and sound segregation is that the way a number of smaller county jails deal with that is they don't create new pods. They create complete and total solitary isolation for the safety of the youth, which has the most devastating effects. It's been equated to torture when you talk about solitary confinement of youth. And so we are not there yet. Right now, our 17-year-olds are in Gen Pop. We will be moving to that place once we start getting into compliance with JJDPA in its most recent reauthorization.
Is that January 2021 or June or September? Do we know?
I honestly don't know the date in 2021, but I'd be happy to find that information and provide it to the committee.
Yes, please.
It's an important question because there is an enormous cost implication for adult jails if they have to segregate 17-year-olds totally in the 140 jails in Georgia. Thank you.
Thank you. Representative Sharper.
Thank you, Madam Chair. In looking at that, whenever that goes into play, I think what you may see in reality is some of the smaller counties, when they do get a 17-year-old, if it's something kind of minor that they could charge with, being that the strain on that, you may have a little old-fashioned of, don't do this again, or take it to your parents or call your parents. But I would just like to, probably figure out if we can get that information from those smaller jails and ask them, what is your plan? Just get some type of survey from them, and I would be interested to know what would happen, because I think a lot of them that really won't be in a position to create a whole nother pod or even a whole area, they're gonna have to get with their officers and have a little meeting, and I think we're gonna see something interesting with that. So I just want to throw that out there, or you can respond to
I will
it.
say that historically, nationally,
Mm-hmm.
the solution has been segregation, we're not arresting. Because arrest powers come from our police officers,
Mm-hmm.
and our police officers bring you into the jail and the jails don't have the authority to not book you once you show up.
Right.
And so historically speaking, what we see in the smaller localities is segregation and isolation instead of, let me send you home for a minute, young boy.
Okay.
And the answer to the implementation date is December 21st, 2021.
Hmm.
I will be talking to Director Norris about that.
Yeah.
So,
Thank you.
any other questions? All right. Thank you.
Thank you.
Next stepping to the podium is Ben Githea to bring you a Superior Court perspective on the 17-year-olds impacted by HB 440.
Good afternoon, everyone. My name is Ben Githea. I'm honored to be here speaking before you all. I come both in a professional as well as a personal capacity to speak to you all. I grew up right down the street, seeing the gold on the top of the dome, and never envisioned myself being before you. I speak from personal experience, age mates that I grew up with. I also speak from about 11 years of being a public defender out in DeKalb, where I've represented clients in state court, as Jason just indicated, as well as for possibly the past 8 or 9 years, 17-year-olds charged with adult crime, with felonies, and in Superior Court. So the first thing that I wanted to come to you and address was arrest. The main difference between an arrest of a juvenile offender and a child being charged as an adult is that when they're arrested, a bond is going to be placed on them for them to get out. They don't normally have the resources to pay that bond. They're 17-year-old children. They're mostly dependent on their families for all of their sustenance, for their food, their clothing. So it's a burden on the parent. And so they're going to stay in jail unless they're fortunate enough to get a signature bond, unless they're fortunate enough to come across a judge who can be compassionate and maybe make accommodations so that the family members could get them out. And of course, we're dealing with an impoverished group. Usually the people that I see, people coming from a lower socioeconomic class. And so they normally don't have those resources. Not only do they not have them, they're not working, they're usually in high school, but it's also not coming, their parents aren't usually in a particular, aren't in a position to be able to just dole out thousands of dollars to bond their baby out of jail. So that is what I'm seeing immediately. Also, the length of confinement after arrest. If they're not granted a bond immediately within 72 hours of their arrest, they're entitled to a hearing. They likely won't see a judge for another 2 to 3 weeks, which will be their probable cause or preliminary hearing. At that point, it's possible that they could, if they're lucky, get a bond and get out. But by that time, like I said, 2 to 3 weeks has passed. And if they're in school, they've missed 2 to 3 weeks of school. That's a large amount of time to be able to recuperate from. So again, it puts them in a position to not succeed. And again, they are 17-year-olds. They are children. I won't go into the science. I think you all have heard a lot about that they are the same as a 16-year-old. Also, if they are fortunate to get out of jail and they're not languishing in jail, the next court that they get, they have to wait for indictment. This could be years down the road. This could be 1 or 2 years. We're talking about a 17-year-old kid who, say he got plucked out of high school as a junior. So now 2 years have passed. His class has graduated. He's possibly missed prom. Maybe if he's fortunate, maybe he's taking some classes somewhere in order to get his diploma or his GED. Otherwise, he's been precluded from school. He's been separated from the track that he was on with his classmates. He now has a different peer group who likely is older, who will be giving him what I would consider bad advice. Another collateral consequence of an arrest, of an adult arrest. His mugshot might be published. This is a 17-year-old child that we're talking about. With the internet now, anything can be found. We've seen it in the past. They're tracing things back 30, 40 years from the 80s. That was before the internet. Imagine 40, 50 years from now what they'll be able to pull. This is a mugshot. This will embarrass that child, cause depression, all types of things that this child who has not been convicted but just charged with an offense has to deal with in his community and in with particular employers should it go that far. Now, public housing as well. If they say they do get a conviction, and they're fortunate to take advantage of what we call first offender, which means that if they comply with the conditions of probation, this will permanently be removed from their adult record. That is a great program. However, with that, say they get a 5-year probated sentence. They're on probation for 5 years. If the judge refuses to restrict their record, then every employer is going to see that. And me, I'm telling them, you've not been convicted of a felony. You can put that on your job application. So now they've been working for 2 to 3 months. The criminal history is running. It comes back and it shows an arrest, not necessarily a disposition. The employer is going to feel duped. They're going to feel like this person hasn't been completely honest with them. They're going to lose a job. I had that happen several times. I just recently represented a young man. He's 22 years old. He's 22 years old now. I represented him on a probation revocation. He was arrested as a 17-year-old. His co-defendant was 16. His co-defendant was fortunate enough to take advantage of all of the resources in the juvenile justice system while he entered a plea to 5 years probation. He did it under first offender. While he's on probation, he has fines, he has fees. He tries to pay those, but he loses his job because every employer sees that he has a theft, and they don't want him to continue employment with them. So it's a cyclical problem. So now he can't pay his probation fees. Adult probation is not sympathetic to this. They want their money. They're not providing resources in the community. And so now that young man is back in front of me for violating his probation for failure to pay fees. Forbid that he gets desperate and goes out and commits another criminal act in order to pay these fees. This is what I see on a regular basis. I've represented thousands of clients. I can't tell you specifically how many have been 17-year-olds, but they do stick with me, the 17 to 18-year-olds. And I beg the DA, because they have all the district attorney, they have all the discretion as to how to basically navigate this child's future. If I'm fortunate, I'm able to get decent resolutions such as diversion. Diversion is great if you can afford it. The CAB, we have some great programs, and I will say this, I have been able to get special cases waived in without a fee. But normally you have to pay that. And again, we're talking about juniors in high school. They are getting this money from their parents more than likely, hopefully for not ill-gotten means. So just more and more barriers. Financial aid. If you've been convicted of a drug offense, I can stand to be corrected, but I believe even under first offender, that could preclude you from getting financial aid. So we tell our youth, go to school, better yourself, get a better education. But this mistake that you made at 17 years old could preclude you from getting financial aid. And again, remember, we're talking about an impoverished group here, a lower socioeconomic group. So another barrier that comes from having a 17-year-old charged as an adult. Immigration consequences. If I'm not able to get a receptive district attorney to lower the charge to what would not be considered a crime of moral turpitude or would not be considered, I believe it's called an aggravated felony, that student who could be here legally with the green card, if they choose to go for their citizenship, it will end with automatic deportation. I'm not an immigration attorney. I'm sure there are certain exceptions to the rule, but part of my job is to inform my clients who have immigration consequences. You will be deported for this offense you made, this mistake that you made as a 17-year-old. So another collateral consequence, professional license. A felony conviction could preclude them from that as well. And again, we're talking about kids who've been diverted from high school. So they're going into possibly training schools to be trained in a particular trade, and now they can't get a license in that because of a mistake they made as a 17-year-old. Jail versus juvenile. Jail's a horrible place. Prison is a horrible place. You have adult offenders who will take advantage of these children, these 17-year-old children. Sexual assault, physical assault. And we're not just talking about in prison, we're talking about in the local county jails. I am in the metropolitan, I'm in DeKalb, so my experience is from DeKalb as well as Fulton and the surrounding counties. I can't speak as to what's going on in North or South Georgia, but assault is real. And they're not gonna pick on someone who is their age or their size, they're gonna pick on a young individual. Now I understand some of these 17-year-olds might be 6'3", weigh 220. The brain is that of a child, regardless of their physical appearance. And that is something that we need to keep in mind. I deal with them on a regular basis. Their appearance might be formidable and you might be intimidated, but when you get to talking to them, you're like, this is a child. He still thinks like a child. He's still making childlike decisions. And this is what I encounter on a regular basis. And to wrap up very quickly, jail, there's no contact visits with their family. Everything's been going to electronic means now. So in addition to that, they have to pay for the jail phone calls. It's a usury amount that these telephone companies are charging for people to communicate with their families. In juvenile, I believe that they can speak to each other through counselors. Commissary, haircuts, thermals, all come with an extra additional cost while you're in jail, as opposed to resources that could be provided to you for free as a juvenile. And last but not least, and I keep reiterating this, they're missing school. They're being redirected. The prison pipeline, the prison pipeline is real. I believe my time is up, but I will welcome any questions.
Thank you very much. Members of the committee, do you have any questions? Okay, thank you so much. We appreciate it. Thank you for coming today. Maisie?
Next, you'll be hearing from Jill Roth to bring you a juvenile court perspective on just to distinguish between what a 17-year-old would enjoy if they were handled as a delinquent in juvenile court versus what you've heard about state and superior courts.
Okay, thank you. Welcome. Introduce yourself to the committee, please.
All right. Hello, my name is Jill Roth. I have been a lawyer defending children accused of crimes for over a decade now. I started in 2008 in Savannah. And I was in Savannah from 2008 to 2015, and since 2015, I've been practicing before the DeKalb County Juvenile Courts, representing children. And I think what I'd like to do is just highlight some of the major differences between how cases are handled in juvenile court versus how they're handled in state and superior court. So you heard first Jason and Ben talk about kind of what happens immediately after a 17-year-old is arrested. They're taken to jail where they will either be granted a bond or where they will have to wait for a bond hearing. In juvenile court, what happens is when an officer decides to arrest a child, what they will do is they will contact the juvenile court's intake department, and an intake worker who is a person employed by the local juvenile court and has training in child development will do something called a detention assessment instrument. You've probably heard of this points system. I think there's a lot of misconceptions out there with what that is. But what the DAI score is a evidence-based instrument that's been validated by the National Center for Crime and Delinquency, and it's used across the state. And what it does is it provides an objective set of detention criteria based on risk rather than our subjective biases. It was adopted in part as Georgia's efforts to reduce disproportionate minority contact. That DAI score is not alone determinative of whether or not a child is detained. There are overrides either to detain or to not detain. So every time a child is brought before an intake worker, the intake worker is administering this DAI instrument and then making a decision on whether or not to detain the child based on the score, but also on the individual facts and circumstances of the case that is before them. So if a child is released pending their trial hearing, they're usually given a court date about 60 days out. If they are held, I think this is where a lot of the big differences come into play. So if the child is held, they have to have their next court hearing within the next 10 business days. If at that hearing they admit to their charge or are found to have committed it after a trial hearing, then we have 30 days prior to the sentencing hearing having to happen. So the timelines in juvenile court move very, very quickly. Also, even at intake, the intake officer can at that point opt to divert the case and send the child to services or any other things that may be needed by the child and the family after assessing the needs and circumstances in that case. Like I said, if they are going to go to court, the hearing is going to happen within about 2 weeks after they are detained, about 60 days if they're not detained. And then disposition can happen on the same day as trial, or it can be at times postponed. And often it is so that the probation department with the court will prepare a predisposition report, which is something where they will interview the child and the family, get background on what the child's needs are, and they will provide a recommendation to the court as far as what the appropriate sentence would be. And part of that would be making sure that the child is receiving whatever services they need to be effectively rehabilitated in the community. And these dispositions are going to be holistic. They're going to try to deal with the needs of the entire family and make sure that the family is getting the resources that they need too. One of the things that our office has in DeKalb that we're very lucky for is we have social workers that work with the public defender's office. We can make referrals for the families to get services they need. So we're addressing not just the crime, but the underlying facts and circumstances that sort of led to the crime in the first place. So the children are getting the resources they need to turn their lives around rather than getting kind of hamstringed with a permanent criminal conviction and arrest record that's going to follow them around and prevent success later in life. We're treating them as children and helping them get the resources that they need so that they can become successful members of the community. I think the other things I wanted to address were in the facilities, things are definitely different. I did listen to one of the prior committee hearings, and I know a question was asked about whether 17-year-olds would be separated from 12-year-olds and vice versa. There is separation of children within the facilities. They're classified just like there'd be classification in adult jails, and they're usually classified by age generally. So the older children, the 16 and 17-year-olds would probably be together, and the younger children are going to be in a different pod. Let's see here. The length of dispositions or the length of sentences are different in juvenile court than in adult court. Of course, in adult court you're dealing with, you could be on probation for some things for up to 20, 30 years. In juvenile court, the max, if the case stays in juvenile court, the max amount of time a child can be sentenced would be up to 5 years. There are several different types of offenses. I deal with children that are charged either with a misdemeanor or with up to a designated felony. So there are certain cases that stay in juvenile court right now. However, any felony, any child 15 or older charged with any felony can be transferred to adult court if certain circumstances are present, if there's aggravating circumstances. But for the most part, those cases do stay in juvenile, and there's a range of sentencing options available, anywhere from diversion to a sentence to a YDC for up to 5 years. So I think, and then as far as probation goes, the probation programs in juvenile court are vastly, probation in juvenile court is vastly different than probation in adult court. Adult court, it's all about monitoring and just making sure you've checked the boxes and appeared where you're supposed to be and paid the fines you're supposed to have paid. In juvenile court, the court's going to order that the child attend evidence-based programs. Those have now been expanded to all 159 counties, which means every county in Georgia has access to at least one evidence-based program that these children can benefit from. Trying to see if there's anything. Also, huge thing to mention would be the permanency of their record. So as far as the openness of a child's record, if they are charged with a designated felony, which means one of the more serious offenses that would still stay in juvenile court, those are actually open record. Everything else is not open. And then for any charge, whether it be from misdemeanor to a designated felony, anything that's treated in the juvenile court, the child will be eligible to have their record sealed once they have completed their sentence and then been off of probation or off of their sentence for 2 years. And it's not automatic sealing in Georgia. They have to actually go before the court, fill out an application to have their record sealed. They'll go before the judge, show the judge that they've completed their sentence, don't have any other pending criminal cases, and have been rehabilitated. And after making that showing, the judge can seal their record. And so that's how record sealing works in juvenile. I think that's all I had. If there were any questions.
Members of the committee, any questions? Okay, thank you very much for your presentation.
Next, we have Mike Randolph, who's going to explain the school justice partnerships that are available in Bibb and Peach counties.
Thank you. Good afternoon. My name is Mike Randolph.
Okay,
I am-
sorry,
Pull
you're
that
really
mic up.
tall,
Okay,
so if you could get
apologize.
that as close as you can. I do apologize before I start getting those texts about we can't hear.
I'm
So,
usually not told to speak up. So, my name is Mike Randolph. I'm an attorney in Macon, in the Macon Judicial Circuit. I practice in Bibb, Peach, and Crawford. 90% of the cases that I handle are in Bibb counties. That's going to be the focus of my talk today. I have been an attorney dealing with juvenile defense work since 1994. So, I'm going to go a slightly different tack and bring it back around to the theme, which is that 17-year-olds are not any different from the other juveniles that we deal with in juvenile court. I'm going to do that by talking about the Bibb County School Justice Partnership. The goal is to just kind of explain to you just what a school justice partnership is, the history of it, Bibb's implementation of it, and then tie that back into the Raise the Age statute. So Bibb began their journey to the school justice partnership in 2018. So that school year, beginning in August, is when we started it. Peach was started this school year, so it's in place right now. Crawford is going to be in place next year. School justice partnerships began in Clayton County under the leadership of Judge Stephen Teskey, and that was done with the coordination of the Annie E. Casey Foundation and their Juvenile Detention Alternative Initiative. They began in 2003 when Judge Teskey decided that there was an issue with kids failing out of school, misbehavior in school, and trying to figure out what they could do to end the school to prison pipeline. That school to prison pipeline is a process through which kids are driven out of the school system and find themselves in the prison. Unfortunately, that pipeline runs straight through juvenile court a lot of times. It manifests itself from the school system based on suspensions and expulsions. Of course, when a child gets suspended or expelled from school, they're going to increase their likelihood of resorting to crime later in life. The way juvenile court gets involved in this is referrals that really ought not to be in juvenile court. And that was the heart of what Judge Teskey identified. So juvenile court was accepting kids that, as he describes it, that we are mad at versus kids that we are scared of, or we're not happy, we're unhappy with, we're mad at, or we're scared of. And so the idea would be that we can focus on kids separately who don't need to be in the juvenile system. And so what they did was the stakeholders came together and they researched it and they came up with some statistics, and this is kind of interesting. A student who is arrested, just the mere act of having that child arrested, which was happening a lot in Clayton County, it's happening in Bibb as well, those kids are twice as likely to drop out. Just by the mere fact that they were arrested, that statistically increases it double. If you take it from the arrest to them making it into juvenile court, it quadruples. It's 4 times as likely for them to drop out of school. So the aim of the school justice partnership is to divert those children rather than send them to juvenile court, to provide the school system with a way to reach those children through a diversion program. So what is a school justice partnership? It is essentially a cooperative agreement between the local school system and the juvenile court. It is participated in by other providers in the community. We have in Bibb County DJJ, district attorney, public defender, law enforcement agencies. Our sheriff is the only one we have in Bibb. Private service providers, faith-based groups, child advocates. And interestingly enough, and what ties into this is state court. When we put together our agreement, we realized, my colleague Amy Bell realized and pointed it out to us, that the need for the things that these kids get in our school justice partnership, those programs that they receive, doesn't end at 17. We have 17-year-old kids that could be and should be in our school justice partnership. And we had to go to state court in order to get that. If the age were raised, then that would not be necessary. Some courts are, some counties don't have state court, but that would be something that would be beneficial. So the heart of the school justice partnership agreement is an identification of various misdemeanors that we are going to presumptively no longer send to juvenile court. There are exceptions to that. If you have a victim who is a school employee, injury to the victim, damage to school property, age and maturity of the victim, those are things that can make something not be referred to the school justice partnership. But if it is referred to the school justice partnership, then the SJP provides the program and the evidence-based program that then the children hopefully will not then recidivate. So what happens when a kid is sent to the juvenile court SJP? We have a coordinator who interviews the kids, interviews the parents, interviews the administrators, looks at the child's record in the school system, and then decides basically two different things. We can either do a written warning, which would be, of course, exactly what it sounds like. It's a warning to the child, and this would be a child who has not had a prior record that would warrant going harsher than that, but it would be a child who just simply received a warning. The next thing that they could do would be a program referral, and we have available in Bibb County, this is constantly expanding, but the general types of things we have are community programs, that's usually ongoing for a few months. We have community service work, either at the school or in the community. We have community workshops, which is usually a one-time event, counseling and mediation or other things that we do. So I want to talk about what this has to do with raising the age. If you go to slide 1, if we could, it's actually the age. There we go, that was it. If you take a look here at the Bibb County numbers, beginning in 2018, that school year in August, through today, we have had 466 children referred to the School Justice Partnership. And if you take a look at those really tall bars in the chart, those are our 12, 13, and 14-year-old children. They represent 18.2%, 18.7%, 19.3% of our overall total. Once you get to age 15, you start to drop off a little bit. You get to 16, those are 16%. You get down to 16-year-olds, they're at 12.4, and then the bottom falls out when you're talking about 17-year-olds. If you notice, we have had 29 17-year-olds in our school justice partnership. That is a third of the number that you see for the 14-year-olds. That's essentially a third of the 12 and 13-year-olds as well. If anything, these numbers show us that the 17-year-olds are not out there committing the offenses that need to be referred to state court. They are not committing worse offenses than we are seeing the younger children committing. They are not any different in the respect that they need the treatment that the other kids are getting. If we look at the next chart, just to show you the focus acts, these on the left-hand side, we're dealing with a fray, that is a fight that takes place in public. Disorderly conduct is the next highest one. Possession of marijuana has 5 as well. But these numbers, I didn't get a chance to run the numbers for you that would show how percentage-wise these numbers match with the other children, but I can tell you they're essentially the same. A fray is the vast majority of the ones that we have, and the disorderly conduct disrupting a public school is basically the same thing. And finally, we look at the written warnings and the program referral slide. You notice on the far right-hand side that there were 7 written warnings. The rest of them, of course, then would be program referrals. So the vast majority of the way things are handled are program referrals. And they would be the things that we talked about before. About 75% of the resolutions are by the program referrals. So if these kids who are 17 were not in the school justice partnership, they would be in what we've already had talked about with the state court. Those programs that they have in state court, as has been said, are kind of check-the-box programs. They are not the kind of things that are age appropriate. They are not the kind of things that are developmentally appropriate for these children, whereas in the school justice partnership, we are dealing with child-facing agencies who interact with the children in a way that is appropriate both age-wise and intellectually for them. So I say all of this to point out, as I started at the beginning, there is, from the numbers that we see in our school justice partnership, no distinction between the 16 and the 15 and the 14-year-old and the 17-year-olds, except that maybe the 17-year-olds are committing less offenses. So we think that that illustrates pretty well why the age should be raised, and we'd ask you to do that. Thank you.
Thank you very much. Appreciate that. Ms. Causey? Okay.
Yes, Madam Chair, committee members, my name is Randy Waldman. I'll do a little bit longer of an introduction than when answering a question earlier. I am currently the chair of the Juvenile Law Committee of GACTL, the Georgia Association of Criminal Defense Lawyers, and I'm also director of the Juvenile Defender Clinic as part of the Barton Child Law and Policy Center at Emory Law School. As you've heard, and I will really wrap up, I think, what you've heard today and over the last several hearings, you've heard a lot that kids are different. I think at your very first hearings on this bill, you heard from adolescent development experts who talked about all of the different ways that kids are different. What I'm here to implore you to understand is that 17-year-olds are kids. You heard that from several of our speakers today. For good reason, our society has chosen to draw the line at 18 for purposes between childhood and adulthood in many different respects. Remaining in juvenile court should be added to that list of ways at which we draw the line at 18 rather than at 17. The U.S. Supreme Court has told us in a series of cases that kids in a variety of circumstances should be treated differently from their adult counterparts as they approach our juvenile and criminal justice systems. This was found to be true for sentencing purposes in Roper, Graham, Miller, and Montgomery, and also in everyday interactions with the police in JDB v. North Carolina. I'm going to read a quick quote from Miller that I think summarizes all of the things that we've been trying to get at. As the court held in Miller, our decisions rested not only on common sense, on what any parent knows, but on science and social science as well. In Roper, we cited studies showing that only a relatively small proportion of adolescents who engage in illegal activity develop entrenched patterns of problem behavior. And in Graham, we noted that developments in psychology and brain science continue to show fundamental differences between juvenile and adult minds. For example, in parts of the brain involved in behavior control, we reasoned that those findings of transient rashness, proclivity for risk, and inability to assess consequences both lessened a child's moral culpability and enhanced the prospect that, as the years go by and neurological development occurs, his deficiencies will be reformed. It is precisely because of these differences that 17-year-olds belong in juvenile court. Let me re-highlight some of the distinctions between juvenile court and adult court. In adult court, 17-year-olds are processed and jailed with adults. They have long, drawn-out proceedings that last months, sometimes years, before there's resolution. They have minimal, if any, programming, either while on probation or in prison. There is no school in the DeKalb County Jail. There is almost no school in our adult prison facilities. What happens is they sit, they wait, they are warehoused until their long, drawn-out process eventually comes to an end, when they have already been too late to go back to school, when they have been forced to drop out, come out, and perhaps, if they're lucky, seek a GED if they don't need to immediately start the working process. You've heard that there are lifelong collateral consequences. An adult offender needs to check the box, yes, have you ever been arrested, regardless of whether they've ever been convicted, even if their case is diverted. That has a lifelong, long-term impact on their ability to be gainfully employed. In contrast, our juvenile system, and we've made enormous strides in this. I think our first speaker, Josh, talked about all of the declines in our arrest rates since 2015. I think it's no coincidence that in 2015, we implemented the excellent work done by this committee or predecessors of this committee in our juvenile justice reform, in our juvenile code rewrite. Those reforms are working. Those reforms are helping to bring down the number of arrests among our juvenile population. And some of the things that have happened are our juvenile justice grant initiatives, or initiative grants, that are bringing programs, as Jill mentioned, to all 159 counties that are working, as the Supreme Court said, to work on the rehabilitative ideal and rehabilitative potential of the juveniles before you. What does a juvenile case look like? What happens to a juvenile who goes through the system? We've heard some horror stories. Yes, there are things that sometimes go wrong, but in the typical juvenile justice case, in the typical case that comes through our system, if a juvenile is placed on probation, our probation officers are school-based. They are in the school building 3 times a week, sometimes more, checking to make sure the child is attending, checking to make sure the child is not getting suspended, checking to make sure that all of the services and supports that are supposed to be put in place around a school system are in place for that child. If there are IEP issues, they're working on those for our special education students. They're checking on a child's home life. They're working with a parent. They're making sure that they're making referrals for counseling services for not just children, but for family therapy to make sure that the child, again, is put on the right path. What we know is that there are evidence-based programs that work. Functional family therapy, multisystemic therapy, aggression response therapy. Those things are evidence-based, they work, and they exist in all 159 of our counties in juvenile court. They don't exist in our adult system. When more intensive community-based supervision is necessary, those programs exist as well. They run in county-run programs, and they run in the Department of Juvenile Justice programs. In DeKalb County alone, we have something called the CAP program, the Community Alternative Program, where there is around-the-clock supports and services for these children. They have multiple probation officers. They have evidence-based therapies, but they also have pro-social activities that they bring these children into. And then when more intensive supports are needed, sometimes the youth are in need of incarceration, sometimes solely so that their brain could catch up and they can grow up slightly before they desist in crime, as the statistics tell us. The vast majority will do. Our DJJ facilities look vastly different than our prisons. Our DJJ facilities, 100% of them have school. DJJ is our 181st school district. It's in fact our largest school district. They have special education services, they have education services, they have diplomas. Students are graduating from our DJJ facilities. Every facility has mental health providers and mental health services for the youth who are on the mental health caseloads. There's programming that includes victim impact, drug addiction, sex offender, and anger management programming. Our children are coming out of our DJJ facilities with the rehabilitative services that will help them reintegrate into the community so that they never make it into our adult jails and prisons and criminal justice system. To conclude, we've said this many times, 17-year-olds are children. We should not give up on them solely because of a mistake that they make as a 17-year-old by throwing them away and throwing them into our adult system. Thank you, and I'm happy to take any questions.
Thank you very much. Members of the committee, any questions? Representative Sharper.
Thank you again. Just wondering on your numbers here, when we look at the 11, 12, 13, 14, 15, 16, 17, but I'm wondering, does this include gang-related offenses?
No, gang-related offenses would not be covered.
Okay, so that's a whole separate.
Those children would be referred straight to juvenile court if they were detained.
Okay.
They would not go through the Civil Justice Partnership.
Okay, all right, and then in your other numbers and your main numbers that you guys have, do they separate gang activity offenses done by the youth, or is clumped in or is separated?
So as far as for Superior Court, gang would be included. Now, as far as for this bill, most of those gang charges are accompanied with the possible violent offense, and I don't believe that those would be included in this, if that answers your question.
Okay.
Now, if it went to state court, it wouldn't be there. It would go straight to Superior Court if it had gang-related charges to it. You know, she
Okay,
would
fine,
speak to
instead of the juvenile, okay.
I can tell you, in juvenile court, gang-related offenses are designated felony offenses,
Okay.
Which means most of them qualify for up to 5 years in a YDC. So those are some of the more serious charges that remain in juvenile court because gang charges are usually added on to some underlying offense. So
Okay.
normally what you have is like you have an entering auto, somebody enters a car, but
Mhm.
it's somehow related to a gang, so they'll add a gang charge on. But the
Okay.
gang charge does make them eligible for designated felony
Okay.
sentencing.
All right. That kind of answers, because I just look at that as we possibly raise the age that, I'm just seeing 12, 13, 14, 15, sometime when they knowing that, hey, I may not get as worse of, a charge, but at the same time, if they're going to be added as a gang charge, I see that it could be, more repercussions versus slap on the hand because, they get the younger kids to do certain things because they know, hey, you'll be out after a while. But thank you. That makes a difference for me.
Okay.
Thank you.
Thank you, Representative Sharper. Anyone else? Okay. Ladies and gentlemen and members of the committee, just to kind of give you kind of a heads up where we are, there are a number of bills that are, believe it or not, juvenile justice does have more than raised the age. I know we've kind of devolved into this kind of single issue, but we will be kind of moving on to other bills, and I expect to possibly have House Bill 440 ready for a vote either this Thursday or next Tuesday, depending upon the will of the committee. We'll determine whether or not it moves forward to rules. So with that, we are adjourned.